The thing is this: if the trust is undone, which would have to be by court order by the 111, that's the court that set up.
I don't know that anybody wants to do that.
Yeah, but I guess to follow that to its logical conclusion, then the beneficiary would be the ward, and in that event, the money would go back to the ward as an adult, incapacitated, and then part of the guardianship, it would fund the estate. But right now, what happened in 2000 when this personal injury suit was settled, those settlement proceeds were used to fund and therefore create the supplemental needs trust, the special needs trust. So it technically does not belong to him. It belongs to the special needs trust for the benefit. This is a tax protection and a benefit protection trust.
But would the ward lose any protection by disclosing?
Well, no. And if the court orders, I'm sure we could get the court a balance of what is in that special needs trust. Typically, Judge, they don't. So the way the IRS works on these settlement proceeds is in order to protect him from his Social Security benefits, it's put in the special needs trust, or what they call supplemental needs trust. And this one's called a supplemental needs trust. But it's used to provide benefits that Social Security won't cover. But if we were to undo that trust, then Mr. Soto would lose those Social Security benefits, all his medical, all his whatever care he's given under Social Security. So typically, those special needs trusts don't go down considerably because by law, they can only supplement what Social Security doesn't cover.
Unless it does, and that would require disclosure. You see, in a perfect world, that you're absolutely right. In an imperfect world where lawyers sometimes take advantage of wards, disclosure would be necessary. So you're right on all counts. You're completely 100% right as to the tax benefits and the IRS situations and the funding of the special needs trust being in the best interest of the ward. From the court's perspective, the question the court has and must always answer is how to protect the wards under the court's supervision.
Well, either he doesn't need a guardian of the estate and just a guardian of the person, which would be what happens typically when somebody's just receiving Social Security benefits, or the court orders that the trustee, which is, and I can't think of the name right now of the financial institution, but to provide the court the annual, because they do have to file an income tax return to show what is on account. It's considerable, Judge. I think it's over in excess of 1.2 million, I think, the last time that I reviewed.
And I guess the question, the answer to my next question could have been not the appointment of a lawyer as, or maybe that lawyer, but a lawyer as co-guardian, but flesh this out for the court, Mr. Tamez. How would this court, or how should any court prevent that situation from reoccurring, but for disclosure?
In other words, the appointment of a co-guardian of the estate when perhaps it's not necessary.
In other words, given this situation, how do I prevent a reoccurrence? That's why we're here. That's why you're here. That's why you were appointed. That's why Mr. Romero was appointed. This is what is pressing on the court. How does the court, other than disclosure, prevent? And I guess, I mean, it wasn't my order, right? I'm just coming in trying to figure stuff out after the fact that it was ordered. But I don't want it to happen again.
Well, Judge, I'm open to the court's suggestion. I think legally would be part of the concern and issue. I can see that because it is a substantial amount of money.
Yeah.
But legally, in the legal context, we do have the special needs trust that was created. Whether the prior attorney recognized that or not, But
there are funds coming off of the special needs trust used for the benefit of the ward every month, every year.
Yes, sir.
But are those amounts disclosed?
Not in the annual report, but
they should be.
We could supplement that.
I'm going to deny them all. If they're funds being used for the benefit of this ward, he does have income, or something that should be listed.
Well, I guess too.
The question is, so, and the problem you're going to have there, and I promise you this is going to happen. The very next time the Office of Court Administration comes and does a complete audit, we're not gonna pass scrutiny because at time one, there's a million whatever. At time two, and now it's at zero. So now the inference is you've gone out and spent $1 million. That's exactly what that report is going to show.
Your Honor, just to I guess to answer that question, we can disclose the bank statements. It's just that in the reports, usually the guardian will receive the money and then make the payments. In this case, the guardian does not receive the money, but everything is paid through the trust. And so I can't put in the report, oh, I received X amount of money and I paid X amount of money, because that's not the way it happens. But we can certainly do what you're asking. I think what you're asking for us is just to disclose the bank statements, and we can do that. But it's just in the report, I cannot put that Ms. Cruz received the money because she does not. And that's why the report is a little bit weird because of that fact. I cannot report that she received any money because she doesn't receive any money.
Well, then find a category and plug it in, or create a new category where she absolves herself of liability, but discloses. I mean, in any event, she is guardian of his estate, so she still bears a duty and responsibility to at least stay on top of it, although she receives none of it. But at least that way, she can definitively show that under her care, trust, as guardian of the estate, everything has been managed well, even though she's not in charge of it. But see, now that we have an initial inventory and accountings that show over $1 million, and now you're showing zero, it ain't gonna pass Austin. I promise you.
Yeah. Well, the thing is, the initial report was actually done wrong, because it should have said zero. And now he's claiming that there was $1 million. So there wasn't $1 million to disclose in the beginning.
Unless we amend an amended annual report for the period, from the creation of the.
Why don't you? Look, the annual accounts are under oath. They're verified, are they not?
Yes.
Right. So if the issue is a non-disclosure of the statements themselves, why don't you just put in the balances and put an asterisk with a footnote or an explanation of some sort that the balance is, none of it is going, or any amount of it isn't going to the guardian of the estate.
That's the way the report reads, Your Honor. So the report reads that Ms. Cruz does not receive any funds, which is a true statement.
And is the balance disclosed?
No.
Yeah, I think unless you give me a different reason, I think I'm going to ask for a full redo. It's
up to you, Judge. Like I said, because Ms. Cruz, I don't think receives the bank statement. It's not, it's not a company, it's not a corporation. It's either we request, similar to what Mr. Tamez had to do, because the bank statements aren't available unless it's requested through the court, because Ms. Cruz will not receive the benefit of receiving a monthly statement. But I guess from what we're hearing from the court is you want us to produce the bank statements.
No, you're not in charge of that. But if she knows the balance, she should list the balance
of the trust.
That's the thing. She won't know the balance. She has to request it. It's not as though she will get all the information beforehand.
The balance isn't in the statements?
No, that's what I'm saying. She doesn't get the statements. She doesn't get a monthly statement.
Did any of the previous accountings have the balances? They had the statements. See, I don't think it's going to pass. I mean, I don't disagree with anything you all are saying, but you can only play the hands that you're dealt, and the hands that you were dealt was full disclosure showing millions of dollars, and now this report, even though it may be true and correct, it shows zero.
Yeah, that's what I'm saying. Like, the first report was actually done wrong. And so what he was disclosing was information that should not have been disclosed.
We can
That's what we're stating to the court.
We can certainly amend, Judge, to reflect that there is a trust, that it is trust property that's being held by a special needs trust, and the balance. And I think what I did, Mr. Romero, is I know that I talked directly to the bank, and that's how I was able to get some information from them, which I'm sure she can too. There's a couple of other complexities with the way they did some things. For example, the purchase of an automobile was not purchased under the guardianship. It was the vehicle is titled under an individual, an uncle. So there are some discrepancies, and that was one of the things that I was going to tell the new guardian was that I think we should consider moving the funds from that trust to another bank. There was a home purchased and it's not purchased under the estates. Those are expenditures that under a special needs trust can be made. So you can buy a home for the beneficiary of a special needs trust. But it's not titled under his name. So those are little things that need to be corrected because legally they're not done right. They're not titled right. They're not deeded right. Why, I don't know, but that's the way things are done.
I tell you what, Mr. Romero, let me do this. Why don't we pause until Ms. Lanessa Garcia returns, and then talk to her, because what I would like is for both of you to put your heads together, and where you leave off is where her client picks up. In other words, so two possible scenarios, but I'm going to let you flesh it out after brainstorming and having a brainstorming session. Either under the first scenario, you amend the entire thing to reflect zero balances throughout, and I don't even know that I would approve that. I'm just saying that's one possible scenario, because then her client is going to pick up the torch when your client passes it to her, and then she's going to report zero. In that event, if this person or either person administers nothing, then the question is there really a need for an estate? Or you and her believe, and you would make the argument that disclosure is reasonable and necessary given the liabilities that each of the guardians is facing for any discrepancies. I don't know. So food to ponder, and I know that it's I know it's more complex than is probably necessary, and it's probably more complex given that nobody in this equation at this point is where the persons that started this.
Yes, Your Honor. We'll certainly do that and hopefully correct it to the court satisfaction, because it is a little bit more complex and layered. Yeah. But I think that you're right in the fact that there is a lot there, and so we'll go back and revisit that. Would you care to give us another? Yeah. And I'll talk to Ms. Garcia as soon as she gets back.
Give us a setting in 30 to 60 days. Well, 45 to 60 days, please. And while that date comes, just maybe I could say it a little bit better. Whatever your decision is, whether it's door 1 or door 2, make sure that door isn't inconsistent with what Ms. Garcia's client wants. You see what I'm saying? So don't put Ms. Garcia in a position to say, I would have elected door 1 and you chose 2, option 1 versus, you know what I'm saying? So just make sure it's consistent so that wherever you leave off, Mr. Romero, Ms. Garcia's client will not object to picking up where your client leaves off.
Well, maybe I can add something that may be beneficial at this point, Judge. So one of the things that I encountered with this particular trust was the fact that they were buying, for example, a vehicle, right? So Lorenzo's mom or the ward's mom says, I need a vehicle. That's fair under the supplemental lease trust.
Right.
So they buy it, they get the funds, they buy it, but the title is not under the guardianship, right? So the house, it's not deeded under the guardianship. So one of the things that there would be a need for a guardian to say, wait a second, if you're going to request money to improve a bedroom because he needs a bedroom for his needs, right? Which is fair under special needs trust, then there would still have to be somebody that would advocate on behalf of the ward, receive those funds, or possibly see that those improvements or those items were purchased. So perhaps you're right. I think that maybe we can't completely just say, well, it's in a special needs trust, it's not guardianship money, but there might be some things that a guardian of the estate would have to review and to prosecute on behalf of the ward with the trustee. In this case, I think there's a better trustee. I've worked with other trustees in special needs trusts that are excellent. That's all they do. And they're a little bit more mindful of those things. So one of the things I wanted to recommend was that we have a a ward of the estate that could make that application to the 111th to do that. So I think it's just maybe how do we properly account to the court that there is a special needs trust and what the balance is and what things, if anything, need to be placed under the guardianship, right?
I think you are swimming in the right direction.
Okay, we'll do.
The next available judge is December the 9th or December the 11th.
Any objection to the 9th, Mr. Temes?
I don't believe so, Judge.
Mr. Romero?
Checking, Your Honor. Hold on. We'll prefer the 11th, Your Honor.
December the 11th
At 2 p.m.
any objection, Mr. Temes?
December the 11th. Oh, no, I can be here.
Mr. Romero, any objection?
No, Your Honor.
So ordered. And I see no person has any vacation letter on file yet. All right, very good. Any other cases for Mr. Temes?
No, Your Honor.
For Mr. Romero?
No, Your Honor.
It's good to see you both, as always. Have a great day.
I just,
Thank you, Your Honor.
Maria Angelica Lamont.
And how are you employed?
I'm a guardianship specialist,
And from your
With
employment,
Health and Human Services.
are you familiar with the case of Miss Jada Ventura?
Yes.
And how did the Health and Human Services become involved with Miss Ventura?
She was in conservatorship with CPS and aged out. So she, it was a referral by CPS.
Okay, and what was the date of that CPS referral?
April 7th, 2025.
Okay, and how old is Miss Ventura?
She's 18.
Okay, and is she currently residing in Webb
I'm sorry,
County?
I missed that. I'm sorry, how old is she?
She's 18.
18. Understood. Thank you.
And is she currently residing in Webb County?
Yes, she is.
And does she own any property?
No, she doesn't.
Okay, and what is her monthly income?
$342.33.
Okay, and is that from Social Security?
No, it's from a program called In-Kind Support and Maintenance.
Okay, and is that the only income she receives?
This is the only income she has.
Okay, and in your opinion, is she indigent?
Yes.
And have the events necessitating the need for guardianship occurred within the last 6 months and continue to this date?
Yes.
And do you believe these are isolated instances of neglect or bad judgment?
No.
And can you tell the court the exact nature of Ms. Ventura's incapacity?
Well, she's diagnosed with autism, autistic disorder, and intellectual disorder, moderate to severe.
And based on your observations, in your opinion, is Ms. Ventura able to properly take care of herself?
No, she needs assistance.
And what kind of assistance? Why is she not able to properly take care of herself?
Well, she requires supervision, prompting to get her daily skills done, assistance with medication maintenance, managing her benefits, acquiring clothes and food.
And have the parental rights of the parents of Ms. Ventura been terminated?
Yes.
And does Ms. Ventura have any other family members?
She does have a sister, an older sister, and she has a younger sister.
Okay, and just to make the court aware, her sister is also under guardianship with the Health and Human Services Commission. Is that correct?
Yes, that is correct.
Okay. And does Ms. Ventura have any other family members that you are aware of?
No.
And have you executed and filed an affidavit stating that notice of this guardianship proceeding has been given to all known family members?
Yes.
And in your experience, what is the nature of involvement of any family of the proposed ward?
There is none.
Okay, so is it safe to say that no family has come forth in contacting you about assuming guardianship of Ms. Ventura?
Correct.
Okay. And are you asking this court that the Health and Human Services Commission be appointed guardian of the person of Ms. Ventura?
Yes,
Do you feel it's in her best interest?
I do.
Is the Health and Human Services Commission qualified to act as guardian?
Yes.
Is the Health and Human Services Commission required to post a bond?
No.
And are you prepared to take an oath on behalf of the Health and Human Services Commission?
Yes, I am.
Your Honor, at this time I'll pass the witness.
Mr. Warstack?
Very briefly, Your Honor, Ms. Lamont, do you remember we spoke on August 4th, 2025 about this case?
Yes.
And I interviewed you about the proposed ward and asked you several questions related to the application.
Yes.
Has anything changed? Have any of your answers changed to the questions that I asked you since that date?
No.
I pass the witness, Judge.
Any other questions for Ms. Lamont, Ms. Bonilla?
No, Your Honor, no further questions. We would just ask the court to take judicial notice of all documents in this case file, including Exhibit A, which is the determination of intellectual disability, Exhibit B, the affidavit of the guardianship specialist, Exhibit C, which is the affidavit of the CPS caseworker, and Exhibit D, which was the order of termination of parental rights.
Buckle up, guys. Today we are stepping straight into a courtroom where money, power, and responsibility collide. In just a few seconds, the judge and attorneys expose the core issue, a special needs trust holding serious money and the explosive consequences if it's undone. This isn't just legal talk. It's about who truly controls the funds, who's protected, and what happens if the court intervenes. From the very start, you feel the tension building as millions of dollars and a vulnerable ward are placed at the center of judicial scrutiny. The intro sets the stakes fast, clear, and heavy, pulling you into a case where one decision could unravel everything.
All right, Mr. Warstack, your report and recommendation, please.
Your Honor, on, let's see, August 4th, 2025, I filed a written report in this proceeding, which speaks for itself, but I will summarize my conclusions and recommendations. And that is, based on my work performed in this case, including meeting with the proposed ward personally, I believe that she is totally incapacitated as defined by the Texas Estates Code, that it is in the best interest for a guardianship to be in place for the proposed ward. I'm not aware of any less restrictive means or alternatives that would adequately protect her, and I have no objection to and recommend the appointment of the Texas Health and Human Services Commission as the guardian of the person of the proposed ward as requested in the application.
You reminded the court. Thank you for that, Mr. Warstack. First question to you, Mr. Warstack. Anything that the court should know regarding fees?
Well, my understanding is that the department does not pay ad litem fees and that I have to apply to Webb County to pay my fees in this case, Judge.
Yes, and if you are due and owing any amount, I tell you what, so would you like to make a request?
I've kept track of my my time in the case, Judge, but I haven't put together an application for fees. I had my secretary call the district clerk's office and ask what the procedure was, and they said that the case had to conclude and then I could file an application for payment.
If you want to make the request, I can put you under oath and you can put whatever you want on the record.
That's fine, Judge.
All right. Would you raise your right hand? Do you solemnly swear or affirm that the testimony you will provide in this case will be the truth, so help you God?
I do.
You may lower your hand. Mr. Warstack, on fees, what would you like the court to know?
Judge, I was appointed in this case back in June of 2025. I performed work including reviewing the application for the appointment of the permanent guardian of the person of the proposed ward. I read and reviewed all of the other documents delivered to me by the applicant's attorney.
All right, guys, this is where the courtroom pressure really mounts. As the hearing unfolds, the judge zeroes in on a troubling contradiction. Reports once showed over $1 million, now they show nothing. That gap raises alarms about disclosure, audits, and accountability. Lawyers defend the structure of the trust, but the court isn't satisfied with explanations alone. It wants clarity, proof, and consistency. The tension peaks as warnings of failed audits and personal liability surface. Then the focus shifts to a second guardianship case, grounding the drama in real human consequences. By the end, the court delivers firm rulings, fees are assessed, and authority is clearly asserted.
I've read and reviewed the docket sheet for this proceeding. I filed an answer for the proposed ward on or about July 28th, 2025. I sent a request for documents and information to the applicant's attorney on or about July 28th, 2025. I went to the Happy Families facility on Hillside Road and personally interviewed the proposed ward on July 31st, 2025. Also, I interviewed Ms. Lamott on August 4th, 2025. I spoke with the applicant's attorney, Ms. Bonilla, on July 30th, 2025 about the case. While I was interviewing the proposed ward, I also spoke with Noel Jaramillo, who is the person in charge of the Happy Families facility, about the proposed ward. And based on that work, I feel that a reasonable fee for my services in this case would be $1,000.
Any questions for Mr. Warstack, Ms. Bonilla?
No, Your Honor, no objection.
All right, thank you, Mr. Warstack. Mr. Warstack, I had brought up an important point, and I made a note, and I forgot to ask before ceding the floor to him. But Ms. Lamont, have you or has someone within your department considered any lesser restrictive means for the proposed ward in this case?
Yes. Yes, we usually consider family, friends, and there is no one else. And no one has come forward wanting to be a guardian for her.
I think that's the court's point. Lesser restrictive means are something else, not the same thing with other people. So did the department, I just need to put it on the record. I'm confident that I know the answer, but I don't want to presume, and I want to have it on the record. So did the department consider any other alternatives to guardianship that could accomplish similar or the same purposes that would be less restrictive in this case?
Yes, Your Honor.
All right. And what was your conclusion?
No, there isn't.
All right. Any follow-ups, Ms. Bonilla?
No, Your Honor. Generally, yes, it is our practice to consider all least restrictive means to avoid guardianship. We did look into this, supports and services, different things of that nature. However, there was nothing feasible that would be in place to necessitate the need for guardianship.
I believe it. I just wanted to make sure that there was some
yes, Your Honor.
testimony on the record. I mean, I can't presume anything. I mean, I think it's true, but it actually is. All right. Well taken, Ms. Lamont. In the case of Jada Roslyn Ventura, cause number 2025 PB638L2, the court finds that it has jurisdiction over this matter, meaning this is the proper court forum and venue to consider placing Ms. Ventura under guardianship. The court hereby takes judicial notice of the entire case file, including Exhibits A, B, C, and D, the application for appointment of a guardian of the person, the medical report, the Judicial Branch Certification Commission certificate, the citation by posting, the citation by personal service, the waivers, and the answer of the attorney ad litem. And now the court has also had the benefit of your testimony and his. And the court also takes judicial notice of the applicant's affidavit for proof of notice. The court makes the following findings. The court finds that this proposed ward is wholly incapacitated. The court finds that it is in her best interest to have the court appoint a full-time guardian for her person. The court finds that her rights of her person and property will be protected by the appointment thereof. The court finds that other alternatives that are less restrictive have been contemplated, considered, and have been excluded. The court finds that there is no method feasible or possible to avoid the appointment of a guardian. The court finds that Ms. Ventura is wholly incapacitated. The court finds that the department has acted in good faith in the prosecution of this application. The court finds at this time that it is in Ms. Ventura's best interest to appoint the department as guardian of the person. The court, taking into consideration Mr. Warstack's testimony, finds that $1,000 in attorney's fees in this case are both reasonable and necessary. The court will prepare its own order so that we get the language right on funds being dispersed from Webb County. For that matter, the request is well taken and the application is well taken and granted in full. Court is signing the order.
Thank you, Your Honor. We have nothing further. May we be excused?
Give me 1 second. I think there's other deadlines. Ms. Rodriguez?
For orders due, Judge?
Oh, we have the orders. Any other deadlines on this case?
Inventory, Judge.
Thank you. Give me an inventory date.
December the 9th at 2 p.m.
December the 9th at 2 p.m. is the inventory. But the inventory would be for an account. This was just of a person.
That's correct, Your
That
Honor.
is correct, Judge.
So one more time, Ms. Rodriguez, any other deadlines that I just don't want anything to fall through the
No,
cracks.
Your Honor.
All right. I've signed the proposed order. It is in due form. Ms. Lamont, do you have any questions for the court?
No, I do not.
Ms. Bonilla, anything else on this case?
Nothing further, Your Honor.
Mr. Warstack?
Nothing further, Your Honor.
Good to see you all. Thank you all for your service. Have a good day.
Thank you.
Thank you.